Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. So today we are talking about the fourth question, which is holding interest in property, and also discussing how property might be taken away through the constitutionally sanctioned process of takings. In other videos, we discuss the particulars of regulatory takings and also a key case, Penn Central. Focus now is the 1992 Supreme Court case of Lucas versus South Carolina Coastal Council. So as the name suggests, we are working here in the Palmetto State in South Carolina and its beautiful coast. Lucas is one of a group of developers that started redeveloping the barrier island near Charleston with other developers in around the 1970s. He has, in this case, bought a piece of property and he has the intention of building homes on it. It is located smack on the beach. Unfortunately for Lucas, 2 years after he purchased the property, the state adopts a Beachfront Management Act. That act prohibited construction in certain parts of certain coastal properties. There are no exceptions. So if you know South Carolina, you might know that it's been hard hit many times with hurricanes. It's probably not smart to build in places where the beach is shifting and eroding. So if you look at the law on its face, it makes a lot of sense. This might be even more true today when we have a much more expanded knowledge about climate change and sea level rise. But the common sense aims of this law don't really make Lucas any happier about the fact that he could not turn a profit on the property. He is a developer after all. So he files a lawsuit in state court claiming the state had effectively, through the regulation, created an unconstitutional taking. Relevant to our discussion, he claimed, and the state did not dispute, that the regulation from a factual perspective denied him all economically viable use of the property. No state would ever make this mistake again, and you'll see why in a moment. So the case made its way through the courts and ended up at the Supreme Court. The opinion of the court is written by Justice Scalia, who tells us the holding early on, and that is denial of all economically viable use is a per se taking, unless the use is a nuisance at common law. There's another video putting the per se concept in context, and I encourage you to watch it, and yet other videos on what a nuisance is. But essentially what the holding means is that the court has established a bright line rule that clarifies how a takings claim that fits a particular set of facts will be treated. So Scalia and the court spent a lot of time justifying this new per se rule. The opinion reviews the burdens on the property owners and again accepts as undisputed facts that there is a total deprivation. It says that the total deprivation is so much like a physical appropriation, also a per se taking, as the Loretto case established, that we might as well consider this total deprivation a per se taking also. The court also discusses the idea of being singled out. So we do not want property owners to feel like they're bearing the sole burden of suffering for the common good. Here, a total deprivation of economically viable use of property is very dramatic. So compare this property owner's claim to the claim of the owners in Penn Central. In that case, the property owners also felt singled out, but they end up losing. And why is that? I think it's because they didn't suffer a total deprivation. You see Lucas end up winning in this case because the extent to which his property has been taken. To understand how much property has been taken, if something is a total deprivation, we have to understand what the denominator is. The denominator is the amount of property interest that that, in other words, the denominator is the overall amount of property interest from which property might potentially be taken. It is pretty hard to know whether someone has been deprived of some or all economically viable use unless you know that denominator amount. We explore the question of the denominator in a video called The Search for the Denominator, and a few additional cases that will help clarify how the Supreme Court continued to think about this term. All right, so denominator aside, one last question about the majority opinion, or one last comment, revolves around its concept of nuisance. The court really seems to care about whether the activity being regulated is a nuisance. If there is an exception to the Lucas per se rule, meaning if there is a nuisance that's being regulated, then that particular regulation will not be considered to be a taking. Okay, now going to a concurrence, Justice Kennedy, who concurs, he suggests that thinking about whether regulated activity is a nuisance is the wrong thing to do. He thinks that nuisance alone shouldn't be the only exception to the Lucas rule, but that is not the majority's finding. We also have a dissenting opinion from Justice Blackmun. So his famous phrase here in this line is that the court launches a missile. So quote, launches a missile to kill a mouse. Again, this is a famous quote reused again by lower courts and in other cases because of its catchiness. So what he says, what that means is Lucas still has the ability to sell land to neighbors for their yards. Lucas can still picnic, he can still swim and camp on the property, he can still exercise ownership rights by excluding others. He references the original interpretations of the takings clause and the limitations of the takings clause and says that in fact, property owners were expected to contribute their land for public benefit. Justice Blackmun adds that Scalia is also overstating the role of nuisance in takings clause analysis. Again, going back to the history of the takings clause, none of the history indicates that nuisance played any role at all. So we had that history lesson from Justice Blackmun, but it's really Justice Stevens' dissent that goes after the Lucas decision and at its heart. So first, he thinks that with the Lucas decision, developers are going to start gaming the system so that they can maximize their losses by minimizing the size of the denominator. We will see how that plays out in the video on the search for the denominator. Second, he thinks that the rule prevents states from changing their laws. He really thinks that states will be too worried about passing laws that could be construed as total deprivations, and so they will under-regulate bad behavior. Finally, he thinks that the court misses the mark by calling the act, which is generally applicable, a taking. He says he doesn't see a particularized injury here that he thinks might be necessary to justify the finding of a taking. Okay, so those are some of the views of the court. You can see that it's very divided. Some commentators have criticized the majority opinion for going too far. Some say it doesn't go far enough. It has certainly caused confusion for plaintiffs as they try to fit their facts into the Lucas framework. So that is one of our per se regulatory takings cases. Very important one that has had a very long reach into the lower courts and into subsequent judicial decisions. I will leave it there. I will hope to connect with you on Twitter or through my website where you can sign up to my mailing list, and I will see you next time.